Welcome back to day 2 of our symposium, Revoking Irrevocable Punishment. We had a great day yesterday and we're so thankful for everyone who could join us. If anyone is interested in watching or missed any part of yesterday's speakers for any reason, we will be distributing a recording with very clear audio next week sometime. Starting out today, we have a panel discussing Washington and Lee's very own Virginia Capital Case Clearinghouse. Our panelists will be Professor Scott Sunby, Joseph Flood, Don Davison, Bernadette Donovan, and Matthew Engel. Moderating the panel will be Professor Alex Klein. Professor Sunby had originally planned to be here in person with us, but unfortunately a conflict arose. So we will be playing a pre-recorded message from him discussing the early years of the clinic. Scott Sunby is a professor of law at the University of Miami School of Law. Professor Sunby's writings have appeared in the Virginia, Columbia, Cornell, UCLA, and Texas Law Reviews. Much of his research has been conducted as part of the Capital Jury Project, a study funded by the National Science Foundation that is designed to understand how juries decide whether or not to impose the death penalty. His articles have examined a variety of aspects of the death penalty decision and have been cited by over 45 different courts, including the United States Supreme Court. His book, A Life and Death Decision, A Jury Weighs the Death Penalty, focuses on the human side of the decision by listening to how different jurors from the same case decide their jury's decision to impose a death sentence. Don Davison is a director of public service at the University of Virginia School of Law. Previously, she was a senior staff attorney with the Virginia Capital Representation Resource Center, a nonprofit law firm specializing in the representation of condemned inmates. At the Resource Center, Davison represented inmates in their state and federal habeas corpus proceedings and clemency applications for more than 13 years. In 2017, she was awarded the Bill Geimer Award by her peers for being dedicated capital defender. At the time of abolition, she represented the last 2 inmates on Virginia's death row. Both men had their death sentences commuted to life without parole. Davison earned her BA in theater with a minor in psychology from the University of New Mexico. She earned her JD and graduated Order of the Coif from Washington and Lee University School of Law in 2007. At WNL Law, she was in the Virginia Capital Case Clearinghouse, helped find Students for an Innocence Project, and was a staff writer for the Washington and Lee Law Review. After graduating, Davison clerked for U.S. Judge James P. Jones of the Western District of Virginia. Bernadette Donovan is an adjunct professor at Washington and Lee School of Law. She teaches death penalty law. In 2006 to 2017 and 2020 to 2021, Donovan was a visiting professor and co-director of the Virginia Capital Case Clearinghouse. Before the abolition of Virginia's death penalty, Donovan was co-chair of the Capital Defense Work Planning Committee, which was responsible for Virginia's annual death penalty defense training. Donovan is a partner in Donovan and Engel PLLC in Charlottesville, Virginia. Donovan is a graduate of the University of Virginia School of Law, where she was an executive editor of the Virginia Law Review. Before that, she received her BA with both general and departmental honors from the University of Chicago, where she studied human development with a specialization in mental health issues. Donovan integrates this education into her practice, sensitively assisting clients with mental health needs. Matthew Engel is a partner in the firm of Donovan and Engel in Charlottesville, Virginia. He is a graduate of Washington and Lee University School of Law, where he currently teaches a course on the death penalty. After receiving his JD with honors in 2001, Matthew took a job as a staff attorney at the Virginia Capital Representation Resource Center. After 6 years at VCRSJ, Matthew began working with the Office of the Capital Defender for Northern Virginia. In 2010, Matthew joined the University of Virginia School of Law as the legal director of the Innocence Project Clinic. For 4 years, Matthew taught at UVA while representing wrongfully convicted inmates in various proceedings. For the 2014 to 2015 academic year, Matthew taught at Washington and Lee University School of Law, his alma mater. He also served as the interim director of the Virginia Capital Case Clearinghouse. In 2015, Matthew transitioned to private practice with his partner, Bernadette Donovan. He currently represents capital murder defendants at the trial level throughout Virginia. He also continues to represent wrongfully convicted inmates in post-conviction proceedings. And last but not least, Joseph Flood. Joseph Flood began doing capital work as a student fellow with the NAACP Legal Defense Fund, where he focused on impact litigation in the South. After law school, Mr. Flood clerked for the 11th Circuit, where he drafted several opinions in capital cases. After his clerkship, Mr. Flood represented death row inmates as a staff attorney for the Alabama Resource Center, now Equal Justice Initiative. In 1995, following New York's reenactment of capital punishment, Mr. Flood opened the Rochester office of the New York Capital Defender and represented capital defendants until New York abolished the death penalty. In 2005, Mr. Flood moved to Virginia to run the Capital Defender Office for Northern Virginia. Since 2009, Mr. Flood has worked as a capital litigator in private practice. Mr. Flood continues to represent capital defendants and is a program attorney for the Mexican Capital Legal Assistance Program. And with that, I will turn this over to Professor Klein.
Thank you so much, Claire. I am extremely excited to moderate this panel about VC3, which was the Virginia Capital Case Clearinghouse. I was a student in VC3 from 2015 to 2016. And this experience really changed my life and put me on the scholarly path that I am now, where I research and write about capital punishment. So our plan is to start things off with Professor Sundby's video. And each panelist will present for about 10 minutes. Panelists, I will privately message you at the 2-minute mark just to let you know. And after that, we'll have questions. So audience members, please put any questions you might have for our wonderful panelists.
Hello, it's a real honor to be on a panel talking about VC3. I realize that I'm invited in part because of I've now become my own longitudinal study by getting old enough to be sort of the historian for at least the early years of VC3. I first came to Washington and Lee in 1990, went away, came back permanently in 1992, and of course VC3 had started just a few years earlier. So I was able to watch it develop sort of from the beginning, and indeed served as a director for 1 year during that time when Bill Geimer, who of course is the person who founded VC3, took a leave of absence. So for those of you who watch Beat, I am the Selena Myers of VC3. I was there for a year and no one remembers. But it did give me a chance to see the operation from the inside out. And then, of course, I had many years of working as a colleague with first Bill Geimer and then Roger Grew and eventually David Brooks. So I feel like I know VC3 extremely well and perhaps have some insights as to why it was so incredibly important to Virginia's capital punishment defense community when it was first founded. And there's sort of, I'm told I have very limited time, so I'm going to sort of get right to it. And I made a list and I came up with 5 reasons as to why I think VC3, especially with its founding in the late 1980s, was so critical to setting the helping set the foundation for what has, of course, happened recently with the abolition of the death penalty in Virginia. I was looking at some tributes to Bill Geimer and came across one from Kevin McNally, and this is written in 2001, where he said, "Sad to say, Virginia vies with Texas for the title of death penalty capital of the United States." And of course, that's in 2022, almost impossible to get our head around. But if you were there at the time, and one of the attractions of coming to W&L when I did in 1990 was the death penalty is one of the areas of my research and writing, and it was ground zero. And so it was a time of great distress for those who were trying to abolish the death penalty. In fact, abolition was just a pipe dream then. It was, can we slow down the machine? And I will say that I think VC3 was an essential player in that. And there were really 5 reasons. The first is, and this is again one of Bill Geimer's tremendous insights when he started VC3, was his philosophy was we get death out of the case early. When VC3 started up, most of the actions against the death penalty in Virginia were sort of rearguard actions. The death penalty had been imposed, and now there was an effort to get it overturned. And at that time, it was almost impossible. Not only did you have a hostile U.S. Supreme Court, you had a hostile Fourth Circuit, you had a hostile Virginia Supreme Court that just simply were not open to many of the arguments which eventually, decades later, actually got footholds. And so Bill had the insight that he then pursued relentlessly through VC3, that what we have to do is get into these cases pre-trial and do our best to get death out of the case. I don't know how many times I've heard him say that phrase. And that is how VC3 was geared. And it was because of that that the second reason why I think VC3 made such a contribution came about is it became a real center for resources. Bill and the students, and then later, of course, Roger and David worked tirelessly to develop arguments, to write motions. Many was the time when it would be a midnight call that an attorney would make. Because this was a time when the attorneys who were being appointed were private attorneys who often had no capital experience, sometimes not even homicide experience. The level of representation was very, very low. I want to use the word abysmal. There were, of course, some great attorneys, as there are always some shining stars, even the darkest night. But the overall level of representation was, quite frankly, in the capital area, horrendous. And VC3 went out to develop the resources and the education of these attorneys who were willing to take these cases and help them get the footing which they needed. Every year there was an annual symposium which brought in speakers and was essential to sort of getting this out there. There was the Virginia Capital Digest, which Bill oversaw, which wrote very practice-oriented articles to help attorneys in this area. Which brings me to the third thing which VC3 did, which I think sometimes goes a little bit overlooked, which is that it connected the Virginia capital defense community, which again was, there were no resource centers, there were no capital defense centers. These were private attorneys in little cities and counties across the state who often were being somewhat dragooned into representation. And they didn't really know where to turn. And Bill was essential through VC3 to sort of making Virginia connect to the outer world. And every year he would have the Symposium, which would bring in speakers. That's how I first heard David Brooke speak, who I'd like to think I had a hand in recruiting to W&L later to head up VC3. But it was soon after the Susan Smith case, which I heard him talk. He brought in people like Kevin McNally, Millard Farmer, people who were able to sort of let this community, we would meet in the moot courtroom, and there'd be, somewhere around 100 lawyers. And it made the sort of a sense of community within Virginia, but also very importantly to realize that there were these communities of capital defense attorneys outside of Virginia as well. A fourth thing it did is, of course, through the students' participation, who then became alums of VC3, is it helped develop some very talented attorneys who then went into capital defense, especially in Virginia. I was thinking sort of like sometimes you read in the NFL where there's this coaching tree where so-and-so coached the so-and-so and they go out and they start, coaching a team and they develop the people under them. And so you have these elaborate coaching trees. And in some way, VC3 had its own coaching tree. I named some of my favorite students' names, but I know that I would leave someone off. But when you look at the talent pool that VC3 developed over the years, and especially in those first years when there was very little talent out there. Again, not the lack of talented lawyers, but a lack of talented lawyers who understood the special challenges of capital defense and even the basics of the need to develop a penalty phase strategy even while working on the guilt innocence phase. And of course, that's capital defense 101 now. But back then, that was something that, if you were first assigned to a case and you did not really know much about capital defense, you went where you were comfortable. Guilt innocence, right? And you would be on the eve of trial sometimes in VC3 and learn about a case where mitigation basically had not been done. And so developing this pool of talent that went out and started going into communities and saying, this is how you do it, was incredibly helpful. And the final thing which I will say that VC3 really accomplished in those early years, and then carried over, of course, into the subsequent decades, but in some ways is perhaps the most important. And it's somewhat intangible compared to the other steps which I described. And that is through Bill Geimer and through VC3 in those early years. A lot of defense attorneys who then were appointed in capital cases saw someone in Bill Geimer and through VC3 who was fearless, who had passion, who didn't view a capital case as just another murder case. And it was a time when within the Virginia defense community, there was something of a get along attitude. I'm dependent upon a judge for repeated appointments in other cases. I want to get along with the Commonwealth's attorney. And Bill Geimer was essential in sort of saying, listen, these people are trying to take your client's life. You need to step up to the plate, and we will be there every step of the way. And this is not just being a lawyer. This is a calling. This is a passion. And if you are going to do this type of work, you really need to join in that. And you just can't play nice. There are times you are going to have to file motions that are really going to upset the judge and upset the defense attorney, or excuse me, and upset the Commonwealth attorney. But that is part of the process. And so that's just a quick thumbnail sketch. My timer is going off, so I need to conclude. But I know that the other panelists are going to sketch in a much more detailed sense of VC3.
So we will next turn to Professor Matthew Engel to continue sort of the VC3 narrative.
Thanks, Alex. Is the audio functioning okay here? Great. All right, perfect. Yeah, thank you so much for to Alex and also to the organizers of the symposium for inviting us. It's a real pleasure to be here this morning, and I'm grateful for the opportunity to talk about one of my favorite subjects, which is VC3. I think my role on this panel is fairly limited. I think I'm here primarily to talk about the Roger Groot years, which was the year that I was a student in VC3 for 2 years, from 1999 until I graduated in 2001. And so I want to do that, but before I do that, there was one thing I wanted to mention, which was that there's another director of VC3, and I don't want her to be overlooked. In 1997 to 1998, Penny White directed the clinic. This is obviously before I arrived at Washington and Lee, but the fascinating backstory, Penny White had been a justice on the Tennessee Supreme Court and heard one death penalty case as a justice on the Tennessee Supreme Court and voted, was the deciding vote in a 3-2 decision to set aside the inmate's death sentence, which upholding the conviction, but setting aside the death sentence on the basis of a lack of aggravation or proof of aggravation at any rate. Which resulted in her immediate judicial recall, which is a most unfortunate but perhaps not entirely surprising outcome in Tennessee in the mid-1990s for voting for relief in the death penalty case. So after losing her whatever they call it, recall vote, I don't know what the actual term is in Tennessee. Justice White came to Washington and Lee as a visiting professor and actually ran the clinic for a year, which I think to me just sort of goes to show the caliber of person who is attracted to VC3 and who wants to devote their careers to this type of work. Really, just something I wanted to at least mention. I think Justice White is now a professor at University of Tennessee College of Law. At any rate, I came in a couple of years after that. I didn't know Justice White, and I was in the clinic under Roger Groot. I sort of don't know where to start in talking about Roger Groot. I think maybe I'll just start by talking about the structure of the clinic at that time, because it did change quite a bit over the years. When I was actually looking at law schools, I knew that I wanted to go to a law school that would give me training in the death penalty. I wanted to be a death penalty lawyer. I was very drawn to these types of cases. I sort of was in a fairly unusual position of coming into law school, knowing exactly what I wanted to do. So I sort of scoured the country to figure out where I could get that. And Washington and Lee was the only school at that time that I considered that had a 2-year death penalty clinic. There were a couple of University of Texas had a wonderful death penalty clinic. UC Berkeley was doing death penalty work, but Washington and Lee had a 2-year clinic which was designed to assist defense counsel in capital cases. And that to me seemed really unique and really was the reason that I wound up at Washington and Lee. But it was a bit of a gamble because the way that the VC3 actually worked back then is we had 16 students, 8 3Ls and 8 2Ls. And the 3Ls would select through a pretty competitive and as I recall, fairly rigorous interview screening process. They would select the incoming 2L class. And so, basically my entire first year of law school was spent sucking up to the current 2Ls who were in VC3 and trying to ingratiate myself to them so that I would not have moved to Lexington, I won't say for no reason, but, so my primary reason for moving there wouldn't be lost. But yeah, we had to submit applications and go through an interview with the entire 3L class. I remember vividly sitting in the Powell suite and fielding questions from Roger Groot and from the 3Ls who were currently in the clinic, trying to figure out if I should get one of the coveted spots. Well, thankfully, of course, I did. It was not all for naught, and I entered the clinic. Scott Sunby just talked about the sort of coaching tree that VC3 put into place. That started right from the beginning because we were comprised of 8 3Ls and 8 2Ls. Every incoming 2L was paired with a 3L student as their sort of mentor in the clinic. Mine was Paige McNenia, who was a wonderful student. I'm sure is a wonderful lawyer. I haven't kept in touch with her, but whose father was also a professor. He was my, I want to say my contracts professor. Maybe it was property. I can't remember now. It's a long time ago. Uncas McNenia, who's a longtime professor at the law school. But at any rate, that sort of idea of that coaching tree and that mentoring and that learning from the people who had just gone before you, that was very, very integral to VC3. And to me, it's not surprising that sort of continued amongst the alums of the clinic as they graduated and went on to their careers. And the clinic itself was divided into 2 sides. So you would have 8 students who worked on what we called the case side and 8 students who worked on the journal side. And Scott mentioned the Capital Defense Journal. That was a journal, a law review style journal that focused exclusively on issues of capital defense and was published twice a year. I would turn the camera to my bookshelf. I'm not going to do that because my office is such a mess, but you would see all of the capital defense journals lined up on it. It's an incredibly impressive collection of articles that I still turn to this day. In fact, a couple of weeks ago, I was working on an affidavit for a federal case involving the value of mitigation specialists. And I went back to the journal, to a 2002 journal article that VC3 published that talked about the necessity of having a mitigation specialist in every capital case. And that was extremely useful to show that the standard of practice in Virginia for at least 2 decades has been to have a mitigation specialist in a capital case. The issue in this case wasn't getting a mitigation specialist, but it was about the ability and the necessity of having time to conduct a mitigation investigation in the time of COVID, and how hard that is to go out and meet with witnesses and do a complete social history under current circumstances. So I continue to find to this day the journal to be extremely useful. And that was what half the clinic worked on, basically, was sort of running that law review. And the other half, and the half that I was on, was the case side of the clinic. And our job was to be assigned. Roger Groot kept careful track of all of the cases that were going on in Virginia, and assigned pairs of students, 2L and 3L teams, to assist those lawyers. And the thing that sort of sticks out in my memory the most, and I think part of the big lesson here, is that the lawyers on these capital cases, the ones who perhaps most needed the help of VC3 were not always the ones who most wanted the help of VC3. And I know Joe in a few minutes here is going to talk about sort of working with VC3 from the perspective of a trial lawyer. But of course, Joe is one of those fantastic lawyers who wants all the help he can get, and who is endlessly creative and aggressive and thoughtful, and is going to take full advantage of every resource that is at his disposal. That was not the norm, I will tell you, in the late 1990s and early 2000s. And so what VC3, the way I remember it, was Roger Groot figuring out what needed to be done in all of these capital cases, telling us to write the motions, then taking his red marker and just absolutely savaging them until they got to the point that they were ready to be filed, and then hounding lawyers into filing those motions. I see my 2-minute warning here, so I'll move through this. When I think about how much the standard of practice has changed since I was in VC3, that's what stands out to me. I really vividly remember, being in the seminars that Scott was mentioning at WNL and the Capital Defense Workshop in Richmond, which was an annual seminar for capital defense lawyers. And I would sit as a law student, I would sit in the audience, and I would listen to Roger up there on the podium talking about all the things that needed to be done in these death penalty cases. And I remember one episode in particular, which was going into the restroom in the break between the sessions, right after Roger had spoken, and hearing some, old, crusty old, good old boy defense lawyer bitching about, excuse my language, complaining about, well, that's all well and good for Roger Groot, up there in his ivory tower. Sure, yeah, he wants me to ask for a mitigation specialist. Well, my judge ain't going to give me a mitigation specialist. My judge is never going to do that. And that was the atmosphere in which VC3 was operating at that time. It was an aggressive push to try to improve the standard of practice. But the important thing is that it was a successful push to do that. And I know that Joe will talk a little bit more about this. I know that Doug Ramser on our next panel is going to talk about, the creation of the CDOs and how much that culture changed to where eventually, through the type of aggressive advocacy that VC3 was pushing for, we were able to prevent new death sentences altogether, and sort of create the conditions for what happened last year, which was obviously legislative repeal, which is phenomenal. I could talk a lot more. I wish I'd said more about what an amazing person Roger Groot was, but I sort of got sidetracked a little. I will just say one thing about him, and then I'll turn it over to the next speaker, which is that Bernadette and I later came back and ran VC3 for a few years when David was off, doing his cases. I got some small sense of the amount of work that goes into running VC3. And when I look back on my years in VC3, what I realized is that Roger Groot was supervising 16 law students. He was consulting in dozens of capital cases around the country. He was publishing twice a year a law review journal, and he continued to teach criminal procedure to the incoming 1L class, a big section. What an amazing man, what a talent. He was truly a monster of the profession, and I still miss him quite a bit. We lost him too soon. But the amount of work and talent that VC3 has had in its leadership and has had in its student bodies over the years is really impressive. And I'm glad just to have the opportunity to sort of recognize and talk about that a little this morning. So thank you very much.
Thank you so much. And audience, feel free to drop stuff in the Q&A if you have more questions. I will turn it over next to Dawn Davison.
Thanks, Professor Klein. As I was listening to Matthew talk, I was thinking about how my time in VC3 was very much a transition period. So I was in the clinic from 2006 to 2007, and David Bruck had just come to WNL in 2004. And sort of with him taking over the clinic, there were a number of changes that he implemented. And I recall that I think we were the first year that it was a one-year clinic, and it dropped the journal component for our year. So we were still selected by the students who were the year before us, but they had served 2 years. And so they had the journal component, and they participated in the selection of my class year. So I think we were the first group of students who were selected by David as well. And we felt, I think, a great loyalty to him, and didn't have the sort of growing pangs that, other folks had who had experienced both Professor Groot and David leading that clinic. I was also in the last class that Professor Groot taught. I was in his last criminal procedure class, and he made a huge impression on me. And I remember him working on capital cases and going to see him in his office, and he was still up there, while teaching, working on capital cases. So in VC3 that year, there were 10 of us, and we operated in teams of 2. And each team had a caseload that was made of predominantly Virginia cases, but we did have some federal cases in the clinic. And we also had some South Carolina cases that David had brought with him from South Carolina. We were still in the downstairs space at that point in time. We all had our carrels in there, and we spent a lot of time in there together. This is sort of where we lived. We were very much in the dungeon or the basement, I think, according to everybody else in the school, but we were very proud to be there. We had weekly clinic meetings where we would check in and talk about what was going on in our most active cases. We were actively monitoring potential cases. In addition to our caseloads, we all had other projects that we were working on. So for instance, I was the clinic manager. And I think that my job was basically herding cats. But I also would track all of the potential capital cases in Virginia. And I did that through sort of Google alerts, sort of just keeping an eye open for anything. And it was my job to bring it to the attention of everybody else in the clinic. Other folks were working with the Virginia Bar Association and David to put on the Capital Defense Workshop every year. And so there were these ongoing projects and duties that we split up, kind of like a small office. And that was very much how David treated us. He was our teacher and he was our mentor. And he had literally been our teacher because there was a class component that was a prereq before you could apply at that point in time to get into VC3. You had to take the death penalty seminar that he taught in the fall of your 2L year in order to apply. But he very much, as the year went on, we became sort of like a little legal office, and David was our managing partner, right? But we were all expected to contribute to the overall operation of the clinic, as though we're a small law office. So we also would contribute to the motions bank. One of the ways that we would sort of lure in attorneys who maybe weren't so excited about using VC3 or taking our guidance is that we had a motions bank. And one of our motions was this beastly motion to declare the death penalty unconstitutional in Virginia. The thing was enormous, and it was my job that year to revise it. And I remember feeling very frustrated because it was never going to win. Nobody was ever going to win their case by having this motion granted, but it was the main carrot that we would use to get perhaps teams that were reluctant to work with VC3 to use our services. At that point in time, the CDOs had just recently been created, and they were, not all the model of capital representation that they were, that it was hoped that they would be. They were still kind of going through some growing pains. And so when we worked with teams, each one of our teams in VC3 would have some cases that we were working on that were solely private attorneys. And we would have some cases that we were working on that were just basically CDOs. They would have a private attorney. A lot of times we didn't have interactions with the private attorney. We were mainly working with the CDOs. But even among the CDOs, although they seemed more willing to use our services and certainly seemed to appreciate David's advice and suggestions and guidance, there was just kind of hit or miss on a number of things that were going on at that point in time. The private attorneys were, for them, we were the ones who were still in the business of shilling our services. So we were doing it through the motions banks. I remember taking like a road trip tour of Southeast Virginia with David as we would stop in. I had this feeling we might have been unannounced, but perhaps he made appointments. And then we would show up and be like, hi, you have this capital case. We've been trying to work with you on it. Can we sit down and talk to you about it? And some of them were great, and they were very receptive and they wanted to hear about it. And others, I remember one attorney who, had this big, beautiful, airy office with lots of windows. This is not what he normally did. And I remember him sitting down and looking very seriously at David and saying, have you ever had one of these cases before? And my jaw just hit the ground. I thought, oh my gosh, this man doesn't even know who David is. What cases does he not know about? So that sort of stood out for me. There were some cases too that we had during that year. We started out the year, in 2006, and that was at the same time that William Morva escaped from the local jail. And in the process, 2 law enforcement officers were killed before he was recaptured. And that was sort of how our clinic term began. And we all, were watching the news and watching what's happening, very aware that if he made it out alive, he was going to be one of our clients. And he was. That year also ended with the Virginia Tech shootings. And we watched that as well unfold, fully aware that if he came out of that alive, he would be the next clinic's client. And he did not. It was another thing that stands out for me is I went on my spring break with David to watch a capital case. That was Thomas Porter's case, which had been moved from Southeast Virginia up to Northern Virginia because of the publicity. He had been charged with shooting a police officer. And I remember going and watching part of that. And I remember the strategizing that was going on at night as David would join the Capitol team and sort of talking about and planning the next day and getting to sit in on that. And I think those two cases also stand out for me, particularly because they were both men that I represented later when I was at the Resource Center. I represented both of them in their state habeas, in their cases, and then one in federal habeas and one in clemency as well. The impact that David had, I mentioned he was a mentor and a teacher. He became a friend and a colleague for us. And he gave us access to this world that some of us wanted to join. We got to participate in the Capital Defense Workshop, and we got to meet the other capital practitioners in Virginia. We attended national conferences. He sort of ushered us into this place that we, otherwise might not have been able to go to. He took us to the Supreme Court, and we heard oral argument there on capital cases. We were thrilled. He took us to South Carolina when he was arguing capital cases before that Supreme Court. He used us to help prepare him for his Fourth Circuit arguments. And we got to do real capital work. We were researching, we were drafting, we were helping him prepare for oral arguments, we were helping attorneys There were clinic members in my year who were going out and doing juror interviews for capital cases. We were listening to jail tapes and providing that, that manpower that the capital teams, didn't have on their own. And I think that those of us who worked with David, we left knowing that he believed that we could make a difference, that we had already been making a difference under his guidance and his tutelage. And, as Professor Sunbeam mentioned earlier, there were a number of us who went on to do capital work, and, and a lot of us stayed in Virginia.
Thank you so much. I too have fond memories of updating the motions bank. Audience, for those of you who may not know, William Morvo was the last person executed in Virginia before the penalty was ultimately abolished. Okay, I will next turn this over to Joseph Flood.
Thank you, Alex. It's great to be here, even if it's remotely. My experience of VC3 was that at the core, it was a group of allies in a jurisdiction that I moved to, maybe foolishly, and didn't feel like I had a lot of allies. VC3 was as much a reflection on the cultural shift that began in the early 1990s when the death penalty was rising, as it was a driver of that cultural shift in the legal community and in society at large. And my experience of VC3 was shaped as much by my prior experience as it was by my expectations. I had started doing death penalty work in the South, being mentored by Brian Stevenson at a phenomenal, tiny organization, which was the Resource Center at the time. It's now a large law office called the Equal Justice Initiative. But by the time I arrived there, there was already a structure in place with a ready supply of students from great law schools who wanted to work during the summers, and we'd have a few during the school year. And then when New York reinstated the death penalty, we started from scratch. We had a new statute. I helped create one of the offices, and then I had to build the student summer program, and we would have a couple students, and I built the motions bank in New York, built this, the office and everything like that. And doing things from scratch was pretty great because there were few expectations. We wrote the first motions, we argued the first cases, and our constitutional challenges were seriously considered by the courts. In fact, one that I drafted was ruled unfavorably by my trial judge and led to 5 people being removed from New York's death row, and also contributed to it being held unconstitutional. We had a lot of hostility from the local bar, local judges and prosecutors, because everyone wanted their shiny new toy. But because nothing came before us, we could do whatever we wanted, and we would typically file 100 to 150 motions, and we'd have hearings. We'd actually, in some of the early cases, we'd have hearing weeks where we would argue 60 to 70 motions and have evidentiary hearings sometimes over a week-long period. When I moved to New York in 1995, it was really sort of the worst time to be doing death penalty work, because the death penalty was expanding. New York and a bunch of other states adopted the death penalty. The rate of death sentences was going up. The rate of executions was going up. And me and a lot of other people who moved to New York figured if New York would have the death penalty and it would survive challenge, then we're never going to win abolition in this country. And I moved to New York with that sort of promise, expecting to live there only a few years until New Yorkers voted out George Pataki and abolished it, and ended up staying a lot longer than I had ever planned, and was trying the last death penalty case in New York's history when the high court of that state declared it unconstitutional. And when I started casting about for where I was going to move next, I figured I would pick a state that needed help the most, the place where the death penalty was so entrenched that at some level I would probably end my career as an old man fighting death penalty cases. And that place was Virginia. Virginia at the time, even though Texas executed more people per capita, Virginia did more, and did it quicker and more efficiently with less process. And within a day or two of me accepting the job in Virginia, I got this call from David Bruck welcoming me. And it was a full embraced welcome to the state of Virginia, but it came with some trepidation. Like, do you realize what you've gotten yourself into? A few days after that, I didn't move to Virginia for several more months. Rob Lee got me appointed on a case. I wasn't barred in Virginia, but I was representing a death row inmate here. And I didn't know anything about VC3 until shortly after arriving. And what I came to understand very quickly was that this was going to be a primary ally in doing the capital work that I had been doing. In New York, we had unlimited resources. We had our own budget. We never had to go to court for money. And generally, if we needed something, we would hire an expert, usually the best in the field. In Virginia, there were virtually no resources. They were human resources. It was me and the lawyers I hired and the mitigation specialists, investigators, and VC3. And I think there was that moment, that like recognizes like, where I saw in David and the students at VC3 something of my own image, this unbounded energy and ability to work. Now, when Matt was talking about what Roger DeGroot did, I kind of feel small by comparison. I thought I worked a lot until Matt gave that summary, but I was working when I came to Virginia about 80 or 90 hours a week, creating what would become the template for our litigation. And virtually the only ally I had at that time were the students of VC3. Shortly after arriving in Virginia, I got appointed to a red hot death penalty case, black on white, rape, torture, abduction, just the most horrible things. I got in thinking it was a 2 or 3 year slog to trial. And our first motion for a continuance was denied. And we tried the case within 6 months. And in those 6 months, we cranked out about 80 motions. And half of those were either initiated, completed, or had some fingerprints of VC3. And there's no way we could have done that without the students slogging away with us. When I came to Virginia, that it was typical for a capital defense lawyer to file 10 or 15 motions. And a lot of those would be boilerplate. There would be no hearings on the cases. And there was not even the thought of attacking the composition, the way they selected juries in Virginia. It had never been done. There was almost nothing innovative about it. And we changed that with the excitement and enthusiasm of this group of students who they weren't putty in our hands because they had their own ideas and commitments, but they really, really wanted to learn and were very, very passionate. And that like recognizing like, when they got on our cases, to be welcomed wholeheartedly into doing it, it just fueled this passion. I'm just gonna give you 2 examples of actual tangible litigation that probably couldn't have been done except for the involvement of these students. Early on, we got into a case in Prince William County, which was at that time the death belt of Virginia. A Mexican national had gone on a shooting spree, shooting 6 people, 3 had died. And I had it in my mind that the way they picked juries, grand juries, and petit juries in Prince William County was unconstitutional because the statute on its face was defective. And I had done enough of these cases in New York and in my first years in Virginia to know that the way it's implemented was also unconstitutional. But there was no data set for the race and gender of people who served on the grand juries in Prince William County. So we had to recreate a data set. And during the course of a 2-year investigation, we interviewed 500 grand jurors. We first had to go to court, filing a motion for the veneer fascists. As far as I could tell, never been done before. And then we had to go out and find 500 people. And I think 6 maybe VC3 students jumped in. And over the course of a 2-year period, we went out and interviewed all those jurors, identifying them by gender, by race, and by age. And we brought a compositional challenge, and those students testified. And it was a real heady moment because Virginia had never seen something like this before. The testimony went on for 3 days. We had these students testify, and I don't have the stats in front of me, but there was like 70% of the grand jurors were white men over the age of 55. They never let a young person serve on the jury. Women, I think, were about 20% of the grand jurors. There had never been a single woman who served as a grand jury foreperson during I think we studied it for 5 years. And we presented this testimony to a judge who really didn't understand what was going on. He seemed to be the only person in the courtroom who didn't understand. He didn't think the census was reliable. But here were these students, these fearless students, who not only was knocking on doors for 2 years, but then they came into court to testify about their experience. And their experience was shaped by one of the first witnesses was an investigator from my office who came in and discussed the statistics of his findings. And at one point, the judge started cross-examining him about a specific juror named, I think her name was Melinda Johnson. And the judge asked, how did you know this person was a woman? And my investigator was completely stunned that he got such a question. And he began to describe her physical features, and the judge was shaking his head, like discounting this. Our next witness was a woman from the VC3, and he introduced her as Miss. And my first question to her when she sat down was, do you know the judge? And she looked at me in a quizzical, puzzled way and said, no. And I said, well, how did he know you were a woman? And the judge just about blew his stack. But it was that kind of hostility and skepticism that permeated the legal culture in Virginia at the time I arrived here. And VC was just, the kids were fearless, the students were fearless in changing that. My experience in Virginia was the greatest hostility to innovative, aggressive litigation didn't come from prosecutors. They didn't like what we were doing. They were very hostile, but that was something I had experienced before. The judges, except for maybe that judge, was pretty open to innovative, creative, case-specific litigation. The greatest hostility came from the defense bar. I took over an office, a capital defender office, broken down. And my deputy, who I inherited, told me for the first 2 months, no judge is ever going to agree to this. You can't do that. This is Virginia. And I started wondering if I was crazy. And sometimes my only outlet was talking to David and traveling to Lexington to like get away from this madness that I was in. And he reaffirmed, that it's going to take a while. Joe, you're going to be here a while, so you just get used to it. We're going to change this. And the students of VC3 were really, really instrumental in changing that, whether it was grand jury compositions, filing my harebrained motions, drafting them. The first drafts, I'd have an idea in the middle of the night when I was, sleep deprived and anxious, and I would shoot an email to David, and I would almost always get an affirmative response. This is a great idea. And within a week or two, we'd have the outline of a motion that came from some kind of, random synapse in my brain misfiring. In New York, we were continually coming up with ideas for broad-based constitutional challenges, some of which prevailed. The last case before the Court of Appeals in New York that declared it unconstitutional came from a motion that had been originally drafted years early, and it metastasized and was the undoing of the statute. When I came to Virginia, no one was doing this. Dawn referred to this broad. Can you hear me? I'm frozen.
Yes.
Okay.
Although we'll have to call kind of a pause now, so we can switch over to hear from Professor Donovan.
So do I have 2 minutes?
No, you've gone over.
Okay. Well, it was just great to arrive in Virginia and have a ready group of allies who worked with us, who drafted our motion, and some of these wonderful students then became my colleagues. And it wasn't long before the death penalty went from being a deeply entrenched established institution to reeling on its heels to abolition. Thank you, VC3.
Thank you. And now we will hear from Professor Donovan.
Thank you, Alex, and thank you to the Journal of Civil Rights and Social Justice for hosting this symposium. I'm going to talk a little bit today about the closing years of VC3. As was mentioned at the beginning, Matthew and I were co-directors of VC3 in the 2016 to 2017 academic year, in which David Bruck left to handle the Dylan Roof case, and we came as interim co-directors at that time. And then in the 2020 to 2021 academic year, David Bruck claimed that he was retiring, by which of course he meant taking a full-time position handling a Guantanamo case. And Matthew and I then took over the clinic on a full-time basis for its final year. I'm going to share with you a slideshow. It actually says that the host disabled participant screen sharing. So if that could be enabled, I will share it with you. But until then, I will talk without slides. The difference between the early years of VC3, I think, and the sort of closing years in which Matthew and I had the clinic is that the level of representation in Virginia had radically changed. The times that Matthew and Dawn talked about where VC3 did so much outreach to the private bar in an attempt to raise the abysmal standards that Professor Sunby referred to, those years kind of came and went. And as Joe described, the quality of representation really grew with the capital defender offices. By the time that we were interim co-directors in 2016, the capital defender offices had existed for over a decade and had really raised the standard themselves, continuing to receive support from VC3. But by the time we took it, we viewed VC3 as more of a training ground for young capital defense attorneys. And we viewed it as an opportunity to involve aspiring capital defense attorneys in the community, the capital defense community, because it is a community in Virginia, and also as an opportunity to engage them in real cases. And one thing I enjoyed about co-directing with Matthew is that, of course, it takes two to even attempt to fill David Bruck's shoes when he goes off to do something else. But for us, it also enabled us to not be full-time, and we were able to retain our own capital cases and bring some to the clinic. This is a picture of a client, James Terry, that Matthew and I had during the 2016 to 27 year. And Mr. Terry had a capital sentencing during that year that was focused on the question of whether he was intellectually disabled and therefore ineligible for the death penalty. And the VC3 students had an incredibly hands-on role in Mr. Terry's defense. They went with us to conduct mitigation interviews. They helped write motions, and ultimately they attended, and one even participated in his actual capital sentencing. This is a picture of Mr. Terry during his trial at a break with Kimberly Neal, who was a student in the clinic at the time. And it's a story that's too long, unfortunately, for the time allotted. But for reasons that I unfortunately don't have time to fully explain, Ms. Neal was able to serve as a cognitive facilitator for Mr. Terry during his capital sentencing. So because of his intellectual disability and limitations, we were able to procure a court order that he was entitled to certain accommodations under the Americans with Disabilities Act, one of which was a personal cognitive facilitator who would help him understand the proceedings. And Kimberly Neal, who was a 3-year student in the clinic, sat right next to Mr. Terry during his capital sentencing and helped explain to him what was going on, and pray with him and walk him through this difficult time in his life. And that sort of client-centered, hands-on representation is an ethic that's important to us in capital representation, and something that we wanted to hand off to the VC3 students, is that capital defense representation is about clients. It's about the value in their lives and helping others see the value in their lives. And by having a hands-on role in direct representation, I believe that the 2016-2017 clinic was really able to get that experience. And at the same time, they supported the capital defender offices, because the representation at that time was primarily handled by the CDOs, and we were able to help CDOs with certain tasks. For example, there was a death penalty trial that was handled by the Central Virginia CDO. And it resulted in a sentence of life without parole. And our students hit the ground with us and conducted all the jury interviews in that case, looking for issues. And that case had gone to a capital sentencing. So we also interviewed the jurors about their decision making and how they had come to give a life sentence to this particular defendant. And I think that was a fascinating reminder for the students about the importance of avoiding capital trials as well, because what became clear was that this case was a very strong insanity case, in fact, in which both the prosecution's experts and the defense experts all agreed that the client was not guilty by reason of insanity. But not only was he convicted of the crimes, but he very, very nearly avoided a death sentence. And for the students to have the firsthand experience of talking to capital jurors about their decision making and to see how close someone who was insane came to being under a death sentence in Virginia was a fascinating experience for them. I want to talk very briefly about something that was a large part of the 2020 to 2021 clinic, which is the Parole Project. This gentleman is Bernard Mills, who does horticulture in the DOC and is, I think, a shining example of the type of lovely individual that we represented in the Parole Project. The Parole Project is something that David Bruck spearheaded after that 2017 year that Matthew and I visited. And when we came back for VC3 in its last year, we still brought capital cases with us. But I wanted to shine a little light on David's Parole Project because this was an incredibly meaningful experience for the students and also an opportunity to teach some of the same lessons of representation at a time when VC3's role in capital work was declining just because Virginia's death penalty was declining. In the Parole Project, students paired up in teams and represented individuals who were seeking parole. We tried to select people who were certainly not slam dunk parole cases, but who had compelling of reasons to be granted parole. And the students got to know each of them, got to know the what made them worthy as an individual, what made them special, got to connect with them and got to present those sort of reasons for their crimes and who they had become in their lives. Really, what they were doing is developing mitigation cases for these gentlemen. And they weren't capital mitigation cases. They're different in significant ways that I don't have the time to talk about in this particular session, but they were a wonderful sort of training ground for the type of work you would do in a capital case. And they were also a population that badly needed representation because Virginia had abolished parole in 1995 and grants of discretionary parole were very, very rare in Virginia. Unfortunately, the year that Matthew and I took over the clinic, the Vincent Martin case had occurred, which Mr. Martin had served 40 years for a homicide in which it was, there was strong evidence that he was not the actual shooter. And he was a truly outstanding parole candidate who was granted parole ultimately by the parole board. And it was a huge scandal in Virginia politics and became sort of this flashpoint for the idea that the parole board was just handing out, releasing violent offenders into society, and these sort of, scary tropes were trotted out into the news. And the reality was that they were granting very, very few people parole. And in fact, after Mr. Martin's parole was granted, there was a sort of shrinking back of parole grants by the board. And in our year, our students were completely devastated in the final year of VC3 to find that not a single one of their many worthy parole candidates were granted parole. And of course, we also as professors were incredibly devastated by this result, but more recently, the numbers have been crunched for the 2021 year, and the Virginia Parole Board, that, that liberal parole board that the media was so afraid of, in fact, granted about 2% of discretionary parole cases. And if you included geriatric parole, and compassionate release, they granted about 5%. So in fact, this devastation of the parole board and politicization of the parole board was not limited to VC3, but this was extremely important work and something that David spearheaded at the end of VC3 that I wanted to share. And of course, under Governor Youngkin, we've had that entire highly liberal parole board fired and replaced with people who have vowed to be tougher on crime, which I imagine means going from 2% to 0%. And this is an image from one of Youngkin's campaign ads that focused on how the parole board in Virginia was granting relief to so many murderers. Unfortunately, I think that I'm at my time, but one last thing that I wanted to say was that VC3 always had a large role in the Virginia Capital Defense Workshop. And in the last few years of the Capital Defense Workshop, which was our annual training for Virginia Capital Defenders, David and I were the co-chairs together, which was an amazing experience for me, of course. And every year we selected someone to receive the Bill Geimer Award, which was given to a dedicated Capital Defender. But David was so busy handing these out that he never got to win it himself. And because of the sudden abolition of Virginia's death penalty, we were never able to give him one at the Capital Defense Workshop. However, over the summer, a lot of the Virginia Capital Defense community gathered for a little celebration. And at that event, we awarded David the final Bill Geimer Award that VC3 ever gave out for his, of course, dedication to capital defense. So thank you, David. I hope that this is a tribute to you as well. And thank you again to the Journal for hosting us.
Thank you so much. So we have a little bit of time left. Our panel is scheduled to run till 11:15. If you have questions, please drop them into the Q&A, and we'll, and our panelists will address them. But since I don't see any questions, I get to keep wielding moderator privilege, which was a lot of fun yesterday for me. And I'll go ahead and give everyone a question, because all of you have been involved in criminal legal reform, right, both at the capital punishment level and certainly in other areas, and you continue to do this kind of work and engage. So one thing to think about, right, because Professor Bruck's wonderful keynote yesterday mentioned, right, that there's work to be done beyond abolishing capital punishment. How can we translate sort of the mission, the work ethic, the what made VC3 such a helpful, a small and helpful piece, right, of that abolition story? How can we translate that to other areas that need criminal legal reform? Professor Donovan mentioned the Parole Project, but I know there's a lot more work to do. And I know our students want to know about that.
Oh, I'll keep talking since I already was. Another area that I think that there's a lot of attention is turning to is the issue of life without parole. Of course, when we're fighting the death penalty, life without parole seems like an attractive alternative, but I think also there's a growing sense nationally that it is cruel and it is unusual to sentence someone to the rest of their life in prison without any opportunity to show their rehabilitation. And when you consider the types of resources that are available to someone who is facing the death penalty, they're incredible and they're deserved, and there should be even more. But something that is really striking to me is how quickly funding, resources, and representation fall off if someone is facing life without parole. And so there is a question now of how do we make sure that those people who would have been facing the death penalty potentially before abolition. How do we make sure that they're getting the representation that they deserve? And I hope that that young lawyers take the messages of capital defense representation in terms of vigorous litigation, like Joe talked about, waking up in the middle of the night with your motions ideas, raising all the issues, conducting detailed investigation. There's no reason that people who are facing other sorts of sentences shouldn't also receive a high level of representation. So there's a lot of work to do in that. And I think that the students will find many other areas in which to get fired up and bring the highest level of representation possible, no matter the penalty.
I would like to add too that when I was at the Resource Center, a lot of my time was spent on conditions stuff. Not that we were doing the conditions of confinement litigation ourselves, but sort of dealing, with our clients and working through them through the consequences of those conditions on their ability to, assist in their own case. And I would often tell students that, when to be an attorney doing capital habeas work meant that you were also a spiritual advisor and a doctor and a nurse and a mom and a sister, because all of these things had been taken away through those conditions of confinement. And so you find yourself filling so many roles in that capacity. And I would love to see a bunch of students coming out really fired up and impassioned about changing the conditions in which we confine people in this country, because it doesn't have to be that way.
One thing I would add to that, and I actually see that Professor Hasbrook has jumped in the Q&A to ask about this, and I was glad to see it because it's what I was thinking about while Bernadette and Don were talking, is that all of us on this panel have pretty significant habeas corpus experience. We all at one point in our careers have focused on post-conviction representation and continue to one degree or another. And that, I think, is one of the next areas that there really needs to be some institutional energy being put into that. I think a habeas clinic would be a wonderful idea. It's something we've pitched around a little bit, and we don't really have one. Innocence projects are wonderful at what they do, but of course there's a lot of people in prison who aren't innocent but who are still unjustly incarcerated, whether that's simply because their sentences are disproportionate and unfair, or because they weren't effectively represented at trial. I mean, what I have seen, and I don't want to just repeat Bernadette, although that's always a good strategy, but that drop off in representation once the death penalty is gone. I mean, the simple reality is there aren't going to be capital defender offices for life without parole cases. Death really was different. And it was funded differently, and we have resources that we're not going to have otherwise. But once you sort of get past that top level of the most serious cases, I'm appalled at what I see happening, day in and day out in courtrooms throughout the Commonwealth of Virginia. Cases are under litigated, they're under investigated, they're not tried. And at the end of the day, what that all comes down to is a lack of funding. What that all comes down to is Virginia, you get what you pay for, and Virginia doesn't pay court-appointed lawyers well. And it's not to suggest that there's no good representation out there. There are wonderful public defender offices. There are wonderful private lawyers. But by and large, there's a real lack of high-quality defense representation. And in my opinion, in addition to the lack of funding, another reason for that is that there simply isn't any serious post-conviction review of cases in the Commonwealth of Virginia. If you were sentenced to death, if you were lucky enough to be sentenced to death, then you got post-conviction lawyers. You got Dawn Davison to come in and devote her life to representing you and ensuring that you were represented effectively. But nobody else got that. And nobody else gets that today. So I think that there's a real need for law schools to fill that void and to step into the non-capital arena and start pushing to improve the level of advocacy that non-capital defendants are receiving. So thank you, Professor Hasbrook, for dropping that in the Q&A, and those are my thoughts on it.
I don't think you can ever underestimate the synergistic benefits of having like-minded, passionate young people collecting in some place. I worked in Alabama for nothing. I think my starting salary was $26,000 a year. And by the end of my first year, I had 10 clients on death row. When I took over the Capitol Defender Office, I had a bunch of broken down old lawyers. And in 2 years, we were all young lawyers who didn't meet the qualifications, but the level of representation was astronomically better. Clinics in this country have been under attack from certain political forces for a decade because you have these bright young students willing to work really, really hard for a cause. And when you surround them with like-minded people who have a similar work ethic and passion, it's a really high-powered legal operation. So I think keeping funding in place so that people can do unpopular, difficult, non-paying work is absolutely essential. When law school clinics advocating for the poor, whether it's homeless people or death row inmates, are gone, there's going to be a huge social net that has been removed in this culture and lowers the quality of life, tangibly. So I'm all in favor of funding these clinics because you're never going to get people to work for as little money and do fantastic work as you will in a law school clinic.
And Alex, I know we're out of time, but I just want to chime in and say one other thing, which is that Washington and Lee is in a unique position to do that, just like they did with VC3. And this was something I wanted to say initially and couldn't, but like really only Washington and Lee, maybe not only Washington and Lee, but I think uniquely in many ways, Washington and Lee was in a position to create VC3 and to do that work because it's controversial, it's unpopular, it involves sensational, crimes, and there's a lot of there's a lot of pushback against those things. And a private institution like Washington and Lee, I mean, one of the things I'm most proud of my alma mater is that it embraced that cause, and it did that for over 3 decades. That was the work that they chose to do, and I think that there's another opportunity now to continue that same work on. So thank you.
Thank you all so much for joining us. And students, I saw several of my students in the attendees list. I keep telling you in class that your student work matters. I tell you this over and over again. So, and now there are this panel of extremely smart and talented attorneys telling you exactly the same thing. So thank you all so much for joining us. Everyone stick around. The next panel we'll talk more about the Capitol Defender offices and abolition in Virginia, and it's going to be a really terrific panel. So stay tuned.